The idea of this training is that me and my colleagues, Aida and Begoña, we will going to give you some very simple key knowledge on IP that you as stakeholder can then use to spot and understand the risk that a company is going to when dealing with the IP abroad. So it's a way for you as stakeholders, this addressed mostly the stakeholders, to understand what is going on and what are the risks and how to help the companies, except of course to sending them to us, which is of course the end message of this, but also again, it's a way to you to be more aware of what is going to happen and what are possible problems. So first of all, I'm going to explain or to give you a short introduction on why this is so important. Then Aida will give you more information, more detailed information, and at the end, Begoña will close giving you some practical tips and some practical strategies that are good for the companies. So why is so important? First of all, IP gives legal certainty. This means that when you register your right, you are sure that your right is yours in a way. And so you are ready to defend yourself and to fully exploit the economical aspect of the IP, which is always often forgot, because the point of IP is that it gives you an exclusive right. To take an example of trademarks, trademarks is the exclusive usage of a word or combination of word, color, and images to a company that can use it to identify their product. So it means it's the base of a property right, the right to exclude the others. Then, of course, as I was saying, is the right to use the economical advantages of this kind of rights, which means, among other things, the possibility to license your right. If you don't want to go directly into a market, you can license your right to someone else and gain revenue. But in order to do that, you have to register, you have to have the clear ownership of your right. And the point is that this connection between you and your intellectual property, it's what gives you the good reputation, especially connected with trademarks. Your name, it's your reputation. It's how the people identify you. It's how you build your own relationship of trust with your customers, because they know that if they read Peppermints, it's going to be a good one and not a Chinese one, and this not going to cause them allergy or contain whatever. Is going to be a clear, tested kind of product. And at the end, it's also important, the more your rights are recognized, the more your rights are clear, the easiest is to get partnerships, so this kind of license, but also other kind of agreements, and receiving money and funds. But yeah, okay, this is very nice, so it's important, it's okay, we need it, but why I need to register in the entire world, why I have to register internationally? The point is exactly that. IP is territorial in nature. This means that every country only protects the IP rights that are registered in that country. This, of course, has some regional exception. One big one is the European Union, but it's an exception. The law is national. It's normal when you are a lawyer, you're used to that, but it's not easy sometimes to understand. And this also means that every country has its own legal framework that acts a little bit differently. We discussed it early that the national legislation is going to an international standard now, so there is more harmonization, but it's more harmonization doesn't mean the same law. Doesn't mean the same enforcement, doesn't mean the same cost, the same procedure sometimes. So this is something that company has to keep in mind, that an international protection of the IP, in the sense that I register in one country and this is okay forever and ever, doesn't exist. And then let's take an example. To understand, we discussed it before, like, oh, I have my product, I don't really know what IP I have to protect. The idea is that IP in reality are a combination. Every product can have different IP connected to it, and then you have to choose which one you prefer or which one is more useful to you to protect or register. So first of all, everyone is looking at the trademark, the logo, the name of the company, the packaging also. If for doing this kind of product you are using an innovative process, it's also possible to register at a patent or an utility model, because it's something innovative, it's your idea, it has it's novel, it has industrial application. I lost myself a little. Moreover, we discussed also that there is also this mystical thing that is the geographical indication. That means that your reputation is not just linked to your own brand, but is also linked to the kind of region you are producing. An example is, I'm Italian, it's Parmigiano Reggiano, sorry, but it's true, but the famous one are champagne, cognac, etc. Moreover, you can protect the shape of your bottle. If you are so smart that you created a bottle this beautiful, this is protectable. And this is a form of patent, because industrial design usually goes under patent, or it can be different, it depends, but let's say let's say industrial design, that works more or less everywhere. Okay, you have already a patent in Europe. You cannot register anymore abroad because the patent is too old. So is everyone going to produce the thing the way you do? No, because you protect your own secret. You protect your production via an agreement when you license in a way that is keep it protected, and at that point, if someone decides to spread the information, you can quote them as a contractual liability. So this is also very important to keep in mind. Even when you think that nothing can be done, nothing can be registered for reasons, still trade secrets are there. So address this problem with your employee and learn how to protect them. And last but not least, in this case, copyright can seem not very relevant, because copyright is usually brings to our mind music or films or things like that don't really look like a bottle of nice whiskey. But on the other hand, some part of the design can also be protected. Cognac, sorry, sorry, I'm Italian. We should have put the wine. That's that was decided by the Spanish side. The product is clear. No, but what I mean is that the glass decoration on the bottle, that was one of the reasons why we decided for this, can be protected as copyright, because it's a creation of the mind. It's an artistic creation of the mind. So there are different ways to protect your IP. You have to identify, connected to your product, which are the priorities. That in a way is also a way to say which are the things that are going to be copied first, and which are more damaging for you that are going to be copied. So I'm going to give the floor to my second colleague.
Hello. Yeah, so thanks, Marta. It's very well explained. All a little bit. It's a bit confusing sometimes for a company to identify. I'll go a bit more into this now. So when you decide to go to the international route of commerce, then you have to think about IP. It sometimes is not the first thing that comes to your mind when you're thinking about expanding your business to another market, but it really can make or break your business and venture. So this is why we are here, and we are happy to explain as much as possible. So first of all, as a general checklist, the first thing that you should think about is to develop your IP strategy in advance. So in order to do this, you need to identify which IP is most important to you, but also what are your possibilities to register, and what can you register. So for example, with the Hennessy example, then we can see that basically you could register everything on your product, but with SMEs, sometimes it's not as easy as to go and register everything, because it might not be cost effective. So you would need to decide which ones are the most important to you and which ones would be the most cost effective. For example, in terms of, let's say, copyright, sometimes it's free or close to free, so that could be added to whichever other IP rights that you have and you would like to register, even if it's not the #1 priority to your specific product or service. So again, identify your main IPs, and then when you have identified them, you need to know the IP landscape of this market that you are trying to expand to, and the market conditions. So for example, in many other countries, well, actually in the EU as well, not only the IP is a tool for you to sell your product better, but sometimes it's required in terms of market entry. In particular, let's say a big example would be pharmaceutical products, and some other systems require you to have a patent in order to be able to commercialize these products. So this is something to take into account. You can always ask us, and we can help you identify this. Then after you have do a little bit of research or contacted us about this landscape and market conditions, then a preliminary IP search is quite convenient, because many other countries and many other systems have this thing that is called a first-to-file system, for example. And then this means that if someone else has registered before you, you could infringe their IP by commercializing your product or your service there without registering first. So it's very important to see what's the situation in that market, what is the system that that market enforces in terms of IP, in order to make a more informed decision when you are going abroad. Then after this preliminary, you can do this either both prior to registering or after registering your IP. Again, feel free to contact us, please, because we can give you a little bit of advice on which one would be better for you or what options do you have. But very important is, again, to draft the agreements with partners properly. So sometimes you will need to register first for this. Some other times, if you're just exploring a little bit the market, you might need to sign NDAs or NNNs in order to protect your know-how. So like Marta commented before, you might be giving out your trade secrets for free by accident without signing NDAs. If you are in a business meeting and you're talking about expanding to that market, you should sign an NDA first in order to protect your know-how. And then, of course, register your rights, because we have so many SMEs that think that they are protected because they are protected in Europe. But IP is territorial, so if you don't register or you don't take the measures necessary to be registered and protected in other markets, then you are not. So it's very important to register the rights or make everything clear in order to be able to register or enforce later on. Then you can go to the market.
You're right.
So we've mentioned this a little bit before, Marta and I, and Begoña will also give some tips regarding this as well. But there is national systems of IP protection and international registration systems. This depends on the market that you're going to, depends on your company's products and services. This is something to consider if you're going to more than one place, etc. But mostly, I'm going to do both so they can be next to each other. So national registration is basically you register in each market or each system that you're going to. So let's say you are going to register in mainland China, for example, because I talk about what I know. As Rosella mentioned, there's some exceptions to this dual system, and one of them is the transliteration of the brands. So it might be Chinese, it might be Thai, it might be Vietnamese. This is not always covered, so you need to ask us and we'll tell you. And then you have the other system, which is the international registration system. This is quite convenient for kind of a general approach to registering your trademark or your patent. And it makes sense if you're registering in more than one more country besides your own, or one more system than besides your own, because it's quite cost effective. If you've ever been to the Madrid registration website, let's say, it will give you the choices of ticking down all the countries that you want to be registering your trademark. This has a couple exceptions, but again, feel free to to contact us, because we can kind of help you navigate which exceptions are there or not. Then also, not all the countries are member of the treaties that allow you to do this registration. So sometimes you might have to do both, kind of international registration, and then for that extra country that is not covered that you want to be, do a national registration. And then, again, time, it's important, but most of the systems kind of allow you to register and let's call dibs on your brand kind of thing. So you are already saying this is mine for registration, even though the application process takes its time. You are already the one first to file, like it's so important, for example, in China. And then checklist on whether to do this or that. While it's true that it's similar, the process to register in all the systems worldwide, even though they are national systems, it's kind of an agreement in the legal community kind of thing of what are the requirements to register, but it varies country to country, and that's why we're here, to help you out with these differences. But exactly, each country has its own particularities, so do not assume that it's going to be exactly the same as in your own system, because by assuming you might cause quite a damage to your SME by not registering, for example, or not taking measures like NDAs, things like that. And on top of this, I'd like to mention that there's this possibility of, when things go wrong, if they go wrong, hopefully not, in terms of enforcement, you do not only have the possibility of civil action or administrative action or plainly going to court. There's other options. So there's the option of arbitration, for example, which is a good thing to explore in this globalized world. But also some systems allow things like border measures and border control. And for example, in China, customs can control what goes out of the country, not only what goes in the country. And they will check if that is an IP, a registered IP, and they will stop an infringer to sell out and to export counterfeits, basically. So it's something to explore as well, because just because something goes a little bit wrong doesn't mean that you're going to end up in court in Mexico or in Panama or in China, and you are from Luxembourg and have no idea why you have to go to this court. So there are more options than just going to court, and we can help you with identifying all of these and help you navigate all of these. And we're always in contact, so even if you want to be very global, you can contact the three of us help desks and we'll help you out. And now I'm going to give the floor to Begoña for basically a little bit more of information about this.
Thank you. Thank you both. So, I mean, this is just a wrap-up of what Aida was saying. And I think, well, this is interesting before even going into the wrapping up in general, because as they both said, so the goal of this session and the goal of showing you all this information is that at the end of the day, some of you are SMEs, but many of you are also the middlemen. So you are the person who is in between us, let's say, as service providers, and SMEs or startups. And sometimes, since there is no much IP awareness, let's recognize that, worldwide, what happens is that they come to you with a question and you don't know. You actually don't really know what to answer. So what we're trying to do with these train-the-trainer sessions is to provide you with tools, provide you with information that it's helpful, useful, and that sometimes you may be able to answer directly, but sometimes you know exactly where to find us and to come to us so we can go in detail into that. As he said before, yeah, some measures are faster and effective, and sometimes we just have the idea in the back of our head that, well, if that already happened, if, I don't know, if you're selling diapers and you found a counterfeit of your own diapers in Ukraine, which, I mean, might sound strange for many of you, but I have already experienced as a lawyer cases like that. So do I need to go to court in Ukrainian? Wow, now what? And sometimes there are measures that are not that cost effective that you actually can stop that and will be faster. So, going now into the final points, what we have been talking about almost all day. Common pitfalls. What happens? Now, I mean, I have to say that from the bottom of my heart, I always say that I'm a copyright lawyer, so which is normally the most complicated right, and after what happened yesterday at the European Parliament, probably in Europe, one of the most obscure now. So that means a lot of work for lawyers also in the future, trying to understand what's going to happen with all these upload filters and so on. But I like movies. I like movies a lot. And sometimes I have the feeling that what happens to many of these SMEs when they face IP, it's what happened to Alice in Wonderland when she faced the rabbit. You go down to the rabbit hole. You feel uncertain, unaware, scared. It's like, what's happening? What's going to happen? And probably many of you have heard about this or have identified yourself could identify yourself with many of these, let's say, obstacles. Sometimes it's the lack of knowledge of the sector. It happens. IP, what the hell is that? Copyrights. I mean, I remember back in the day, one of my first trainings to web designers. And I had a question from the floor. So you're talking about patents. No, it's not everything like that. Patents, no? Copyright, trademark, it's the same. It's a patent. And it's like, well, no, actually, look at this more like an onion, no? And you have different layers, or an umbrella with different colors, or different hats. So sometimes that's the problem. You don't know. No, it's like, you have heard about it, but you actually have no clue. No, trade secret far less. Sometimes you don't know how to identify, as they explained before, with the Hennessy bottle. So, okay, so is this a trademark? Could I even have a registration of the trademark for the shape, the 3D shape of the bottle? Oh, okay, so you're telling me that I need to pay for registration of a trademark and then a design or a design patent that will be in the US, because they don't have industrial design, they have the same patents, but it's not a patent, it's a design, so you're already lost in translation. And on top of that, a copyright, which is actually, I don't need to register, but I have no clue how to enforce it if something happens. So it's very difficult. And I mean, as lawyers, we're also aware that that's very difficult. And as the help desk, it's our own day business, no? Protect after commercializing, that has happened so many times, and it will keep on happening. And sometimes the problem is that you have already lost the patent. You have a fantastic idea that it's new, that it's useful, no? Instead of industrial application. That's so European way of understanding. The Americans are much more straightforward on that, like, useful. They use useful, which means the same as industrial application, but if you're not a lawyer, you don't know that. It's jargon. And that it's innovative, that it has an inventive step on it. But you have gone to, let's say, Hanover, that there is this fantastic messe, this trade fair in some days, and you start talking with people about that fantastic product or process that you have. And you start sharing all that information. And a couple of months later, you say, okay, so now I'm going to apply for the patent. I'm going to go to the EPO, here in Munich, well, let's look if I can get a patent. I get all the lawyers around, the drafters, so the engineers, and you have already lost it. The lawyer starts asking you questions, and you start talking about this fair, and you say, okay, yes, I went, I disclosed it. You don't probably use the word disclose. I talk about this and that and that, and the lawyer starts wrapping up or closing the folder and says, we have a problem here. You won't get the patent because you have already lost the newity, let's say, you have already disclosed your patent. Did you sign an NDA? And it's like, what is an NDA? It's like, non-disclosure agreement. Oh, but, I was just trying to pitch my idea to get, people to. So That's important. You need to know that in advance. If you don't know that in advance, you won't get prepared. No? It's like a samurai that goes onto the field without the swords. I mean, no sword, no, that makes no sense. Same happens with, I think Claire already mentioned this before, and that happens a lot. And that happens a lot in the research field. You have clusters, or a lot of people related that go into a research project. And so who is the owner? If we are going to transfer something, who is going to be the owner? Who is going to be the name on the contract? Who is going to be the party? And that's also a sort of headaches. Lack of IP protection strategy, meaning you don't even think that you need a strategy for that. Strategy, I mean, I need a business strategy. IP, that's for the lawyers. No, you need an IP strategy. You need to think about it at the same time as you have conceived your business idea. And the first question is, would I need IP? If the answer is no, fantastic, it's rare. 99.9 probably of the cases you will say yes. It's not that I want more business. I mean, it's the reality. I'm trying to be very, very honest here. It's true. And the do-it-yourself approach. Oh, I don't need anybody. I can just, go on the internet and find the information. This is a digital society. Everything is there. I have this forum here. I have that there. It's true that there is a lot of information available, but knowing how to actually select the information, it's a different story. So I wouldn't recommend the do-it-yourself approach. I wouldn't. So, summing up. This is what we all already said. Think about it. The moment that you have your idea, your business idea in your head, think about, would I need IP? And if the answer is jein, like in German they say, or maybe, then look for an expert. I mean, it doesn't need to be a lawyer. The European Union is providing free services. We're free. I mean, but look for advice. Try to get yourself informed. And then pre-clearance research. There are a lot of problems sometimes, even when it comes to logos, yeah? Or even just, I have this idea, I want to fund a company. Yeah, let's go ahead, yeah. So we need to register the name of the company, no? That's Chamber of Commerce, there we go. Oh, what's going to be the name of your company? Oh, I have this super cool name with this super cool logo, but the name is fantastic, it's super original. Have you cleared the name? Are you aware, or have you searched whether the name has already been registered by somebody else? Or whether, it might be probably, I don't know, here, but in China or in other country, depending, might be immoral or will have some sort of problems. No, but it's cool. I mean, it's trendy. It's going to sell, just by itself, people are going to identify. Yes, but if you haven't done that, you might be in trouble. And if you cannot not even register the name of your company, how on earth are you going to go onto a business proposal to get funding? So there are very, very basic steps. And when it comes to pre-clearance and searches, also there are free tools that the European Union, through the European, the former OAMI, the European Union Intellectual Property Office, has put at the disposal. So we have the trademark search view, the same for the signs, where they have signed collaboration agreements with over 90 international offices around the world, so national offices and WIPO and the UPO, where you can actually 24/7 go and check. So do I have something similar in Taiwan or in Australia or in Panama or in Argentina? And it's just a click ahead from you. They provide even webinars and teaching services to actually know how to use this database in a better way, in a more efficient way. And same happens with the EPO. I mean, I know that, well, Claire already mentioned that before, but I also know the EPO Academy and PIA. And I mean, the SpaceNet database, it's huge, it's fantastic, and it's providing also those services. And they are providing training. So we need, that's a great thing if you are aware of it. So I think that's all from our side. And yeah, just... So the only thing that I want to say is that we're here, as Aida said and Marta said, for you. If you have questions, we're very happy to welcome them. And thank you for your time.
You were taking photos, but I presume also this is this available? Okay, so there you go. If you don't want to do that,
Yes.
you will receive it. You don't have to do that on your phone to make it expand. Yeah, you can do that. Okay, so just before lunch, if it's okay, because I think it's helpful to pull out a few things that you said. I think at the end you said avoid the DIY, the do-it-yourself approach. What struck me from the beginning, it's not just about avoiding hassle, but you did say, you know, it's about reputation building, it's about strengthening your market position, it's about economics. It's not just about avoiding hassle. It's actually about very concrete gains. That was interesting to me as well. Just make sure you don't infringe somebody else's IP. That's another reason why it might be a good idea. Very interesting about the identification of priorities. Because when you saw that camembert, that pie chart, it's like, oh my God, there's that much to think about. I think that was a really, really pertinent example. And who had talked about these trade fairs? Was it, sorry, yeah. Yes, trade fairs has alcohol. Alcohol means, oh, you talk a lot. You talk a lot, damn it. Okay, so I think that was very, very well explained in a very colourful way there. So for me, that's very interesting because I think probably people go along to trade fairs thinking, oh, it's the first step, I'll just see, and then, oh my God. So you must have seen a lot of this as a lawyer. So is there 5 minutes if anyone... there's something that's come in on Slido there. It's very, very tiny. In relation to IP, what is the single most important aspect to consider in each region? Okay, not in each country, I suppose. Wow, we'll be here forever. Are there any striking similarities or differences? Okay. So that's come in from there. Is there anything from the House? Or are you all just desperate to fill your stomachs? That was highly comprehensive. I mean, to be frank, I'd be surprised if there was any stone left unturned. Yes, let's start with you.
I have one question.
Yes.
I am not interested in China, but can I avoid the Chinese take my brand to export? Because I understood that. If a Chinese factory produces paper mints and he sends it to Oman, wherever, can I block him at the front shore?
Yes, you might.
Yes.
Even if
you don't have a trademark registration, yes.
You need to register in China in order to make the customs in China
but he's talking. Yes, but he's talking about the customs abroad. So the product is produced.
The customs of the Chinese or whatever, I don't want to get out.
You don't want the Chinese to export the counterfeits.
Yes.
Exactly.
Yeah, you need to register in China, and then with that registration certificate, you can take that to customs, and then customs will stop the export. Yeah.
In Oman, they will say.
No, in Oman, no. In China.
But
in the border in China, they will stop it before it leaves the country. Then for Oman to accept or not the thing, this is the Oman system. It's not the.
And do they work sometimes or what?
In China,
Yeah.
if
The customs.
yes.
yes. So
Yeah.
if I may add on that. So I mean, if I may, I mean, I know it's tricky, but there was a word that we mentioned, or it was mentioned before, that it's jurisdiction. So at the end of the day, IP as a property right, as we said, the lawyers, property at rem, it's a complicated right because it's a negative right. When you own a bottle, when you own a house, when you own money, you have a lot of positive things, let's say, that you can do with it. When you learn the first thing that you weren't told about what it's IP, no, it gives you exclusivity. Exclusivity means it gives you the right to say no. When actually, when you have a car, you have, let's say, the right to say yes many times. So coming to customs tend to work. I mean, not everywhere, not the same. You cannot guarantee. But in general, things have been improving, and I think the tendency is to keep on improving because otherwise, in a global world, trading and exchange gets more and more complicated, and it's also not good for the reputation of the country. So it's not good to politicians. So.
And you were nodding as well for China. You endorse that there is that. I think that, okay.
That's a need too.
Okay, see how speedy that free advice was? Speedy, free. Okay, just saying. So, just as a last word, if I may, if you wanted each of you to, one of you, two of you, to come back on this, the single most important aspect to consider in each region, what would it be?
I mean, I think the question is, I will say that I will rephrase it, because there is no each region, it's each country.
Yeah.
But on the other hand, the beauty thing of IP, and that's something that I always say to my students when they come to, but I teach business students about IP, which is kind of interesting because they don't have this legal approach, that it's quite an international. It's an international system that works at a national level. So the beauty of that is that we have international agreements that date back from the end of the 19th century. So it's true that there are many general principles, I will say like the building blocks, that are very, not identical, but very, very similar.
Okay. Is that what you were going to echo, or you want?
Depends, of course, what the question mean for. They say aspects. Because aspects can be many things. Aspects can be time, which is, if we discuss in general, what's the most important thing you have to think about is time.
Yes.
And hurry, please. Then if you for aspect intend like the most important risk, etc., so at least for Southeast Asia, I would say would be bad faith registration, because can destroy your possibility to enter the market. Means someone else registering your trademark before you do and trying to sell it back to you, or using it even. This is something very, very disruptive. And I see that it's a problem that is relatively common to the region, everywhere. Because as long as a country is a first-to-file approach, bad faith registration is going to be an issue everywhere. And as for differences and commonalities, as has been said multiple times, there is an international frame, a sort of international level that more or less covers and gives you the build blocks, the elements that are part of the system, and then the differences is mostly in the administrative approach. Like when I have to register, every country has its own administrative system, and good luck with that. We are here for that also, because this is where the differences shows the most, is in the procedure, when you have to actually enforce or actually register your right, the things can change a lot. That will be my answer again.
Can I give the last word to you? Do you want to add anything to that?
I mean, we've discussed this quite in extent, and it's basically that it really is general principles applied nationally. So I don't know what to recommend specifically without knowing more of the person that is asking the question, because maybe they don't have any possibility of having any patent, for example. Yeah. And if they have the possibility of having a patent, China, for example, is a very, very particular system where novelty is required worldwide. So you might need to register in China before you register even in your own country, for example. Copyright, the same. It's Begoña's specialty, exactly.
Yeah, but we were talking about that. Copyright, normally, all over the world, you don't need to look at the morals of the work as such. While in China, if the world is considering moral, you won't get a copyright protection. So it's not even a matter of registration.
Exactly. So it kind of depends on who's asking the question.
Yeah. The particular case.
The particular case, and every case is one in its own, and it will need, the most important thing for each would be different.
Okay. I'm going to wind things up because I don't want to make the lovely catering people too cross, and you need hot dinners and they need to remain hot. But seriously, serious quality, okay? So if nothing else, whoever's online and whoever is here, quality people are on the other end of the phone, webinar training, etc., etc., etc. That has been made very clear, I think. Thank you so very, very much for sharing with us the contents of your considerable brains. You may give them a very warm round of applause. You may take your seats.